Yeah, I'm sure. That's why I learned.
Yes. Here's a copy also. Anybody else want to sign up on these bills Monday?
Who's got my sign-up sheet?
I have it right here. Someone's checking right now.
Okay. And Ed. Yeah. And that we've got the three. Oh, there. Here it is. Here it is. Thank you very much. We're all set now.
Anybody else want to sign up?
You need a drink today. I don't know. There's a lot of uniforms here. Let's see. I think I'm going to first. All right, there's Jill. We're ready to go.
Lindsay gotta have to sit here all
Huh?
Lindsay gotta have to sit here and wait.
Yeah, we should make him wait. Okay, if I can have your attention, we're going to go ahead and get started. We got, first of all, welcome to the House Judiciary Non Civil Committee meeting this afternoon. We've got 3 bills on the agenda today, and I'm going to begin by taking a member of the committee. Chairman Bobby Franklin has House Bill 1439. Chairman Franklin.
Thank you, Mr. Chairman. We're working off of LC 292333S. We've incorporated the comments from yesterday's meeting, where in lines 19 to 21 of the first page, we're dealing with a civil penalty rather than the misdemeanor. And on page 2, we've incorporated the language from Representative Setzler excluding ammunition from the definition of explosive.
Questions from members of the committee? Question? Okay. Chairman Bordeaux.
Could there be even a brief statement as to why this is needed?
This bill came through subcommittee. I wasn't trying to shortchange that.
Right.
Please address that.
After Hurricane Katrina, when law-abiding gun owners were trying to either leave the disaster area and were going through checkpoints, or trying to come back to their homes going through checkpoints, they were having their guns confiscated by the law enforcement there in Louisiana. Though they'd committed no crime, they were not a suspect. They were just trying to flee the disaster and return to their home, and were having their guns confiscated. We don't want that happening here.
Why were the police officers taking guns away from law-abiding citizens?
They had the authority to, and we just want to make sure that authority is not here.
Why were they taking guns away from law-abiding citizens?
That's a good question. They shouldn't have been, but they were.
Your bill would penalize the police officers for taking guns away.
It takes away the governor's emergency power to ban the sale and transportation of firearms on page 2, and it would be a civil offense for law enforcement to attempt to confiscate firearms unless they're being used in the commission of a crime.
Looking at page 1917, it talks about unless the firearm, it says that it's unlawful for a police officer basically to confiscate the weapon during the state of emergency unless the firearm be used in the commission of a crime that is being possessed or carried in violation of state law.
That would be by someone who is prohibited from carrying, such as a convicted felon.
If I say, I'm going to go get that gun, I've got a gun, have I committed a crime?
Not being an attorney, I could not answer that question.
And this would stop the cops from taking the gun away from somebody?
From those who have a legal right to have a firearm, it sure would.
Chairman Knox.
Correct.
Further questions? Representative Everson. You want to address that to the author?
Yes.
I'm not certain about the Federal Reserve, but if they're during a natural disaster, if like a hurricane or a tornado, if the governor calls up the National Guard, then they are then acting in a law enforcement capacity at that point. And we want to make sure that our neighbors serving in the National Guard aren't tempted to take guns away from law-abiding citizens. That's correct.
Hypothetically, the Reserve troops are mobilized by the president, such as the ones that were mobilized in Louisiana, they in turn will move into the state. Will they fall under this law as well?
I don't believe that they were nationalized. I believe they were called up under the jurisdiction of the governor in that Louisiana situation.
Further questions? Members of the committee. Alice Johnson, come around, please.
Thank you, Mr. Chairman. My name is Alice Johnson. I'm the Executive Director and Chief Lobbyist for Georgians for Gun Safety, a coalition of organizations that are working to reduce injuries and deaths from firearms. We oppose House Bill 1439 and this particular committee substitute. We have opposed it when law enforcement officers were going to be charged with a felony. We have opposed it when they were going to be charged with a misdemeanor. And we continue to oppose it as they are going to be charged with a civil penalty in an amount not to exceed $1,000. We don't think that this sends a positive message to our law enforcement officers who work so hard, our National Guard men and women who put their lives on the line all the time. We also are opposed to the second section of the bill, which would remove from the governor his emergency powers over firearms, and the amendment that in the substitute that includes ammunition. We believe that the section that is being removed from this that says, provided, however, that any limitation on firearms under this code section shall not include an individual firearm owned by a private citizen which was legal and owned by that citizen prior to the declaration of the state of emergency or disaster, or thereafter acquired in compliance with the applicable laws of this state and the United States. We believe that that language was added 4 years ago. We believe that language protects individual gun owners. We don't believe that the governor should be prevented from being able to use his judgment along with the General Assembly related to the dispensing, sale, or transportation of firearms along with explosives, combustibles, and alcoholic beverages. We think that right is very important. The judgment of both the governor and the General Assembly in terms of that in an emergency is crucial to the protection of the public safety.
Thank you very much.
Thank you.
Questions of Ms. Johnson from the committee? Representative Bearden.
In your own opinion, do you believe this bill is to punish law enforcement officers or to protect the citizens that have the right under the Second Amendment to keep and bear arms, which law enforcement says sworn to protect also the Constitution of the United States?
I would object to the bill partly, Mr. Bearden, on the grounds that it pits those two groups against each other.
A law enforcement officer who's sworn to uphold the Constitution is pit against a law-abiding citizen who has a right by the Second Amendment to own and keep arms?
I think that there are problems with the legislation that would create that problem if the bill passes. Yes, sir. You're welcome.
Further questions, members of the committee of Ms. Johnson? Thank you, Ms. Johnson. Any further questions or discussion from members of the committee? This bill came out of your subcommittee?
One.
Chairman Knox's subcommittee,
Yes.
with a due pass recommendation.
That's correct.
Okay.
That's the committee sub, I believe.
And we're now on sub 2333S. Is that correct, Chairman Franklin? Any further discussion? What's Representative Abdul Salam?
One of the things that troubles me in this proposal is the goal to protect law-abiding citizens and allow them to protect themselves. One of the things that I never got an answer to was, if we have a state of emergency and if you've got 500 citizens waving guns, how does the law enforcement know which ones are law-abiding?
I hope that's directed to the author.
It's directed to whoever can answer it. I mean, that
Chair recognizes
just frightens
Representative
me.
Franklin.
Thank you, Mr. Chairman. I would imagine that not having served in law enforcement like other members of this committee have, that law enforcement would have to make a determination as to what they have to do in every case that they see. Is a person perpetrating a criminal act? Do they have criminal intent? No different than any other situation that law enforcement finds themselves in. That's why we have highly trained law enforcement professionals, so they can make those types of determinations. We train them to be able to think in crisis situations, and I'm confident they'll make the right determination.
But that, Mr. Chairman, if I may, but that is part of what bothers me. They're trained. So why are we limiting what they're capable of doing? I mean, that's already their job, to assess and determine. And this actually penalizes them for doing that.
All the bill does is guarantees that during an official state of emergency, that a law-abiding gun owner's guns cannot be confiscated. And since the person has the right to defend themselves by not only the U.S. Constitution but the Constitution of the state of Georgia,
I agree.
We're saying don't mess with Georgia with a Georgian's legally possessed firearm.
But how do you tell? You're saying it's a state of emergency, so which means some form of chaos already. And there's a state of emergency with people that are maybe out trying to get food and water, the scenario that you use. How do you look in the sea of people that may have weapons and determine which ones are law-abiding and which ones aren't?
If I could defer the answer to that to Officer Bearden.
Now he's Officer Bearden.
Not now. As the author, Representative Franklin stated, law enforcement officers are trained to make a determination between law-abiding and an offense going on. I promise you, every decision these folks in this room makes in a split second, lawyers and legislators are going to question every move they make, because we got days and days to do it. And they got split-second decisions they got to make, whether something's law-abiding or if there's a crime in progress. If there's a crime in progress, these guys are going to do what they're trained to do, and that's put someone in jail. If it's law-abiding, they understand the difference, and that's where the training comes in. And while a lot of folks that sit back and Monday night quarterback or Tuesday morning quarterback, they don't understand the decisions these guys make, and they will make the right decision.
But I'm saying, I mean, why don't we just let them continue to make the decisions?
Decisions on law-abiding citizens,
How do you
possession
tell?
of their firearms.
How do you look at somebody and tell whether they're law-abiding?
There's not a single domestic that's the same on any call that you go into. If it's a domestic you go into, everyone is different. There's not a protocol for any certain crime. It's a decision they must make under their training.
Chairman Knox.
In the case here that we're looking at a situation where it's not the person with the guns that are the problem, it's the people, the fact that there's no law enforcement available. In New Orleans, for instance, I think it was something like 60% of the police force left town.
No.
And there wasn't anybody there to help the people that were left and stranded by, various failures of government. And so they had to protect their own property and their own lives from people that took advantage of the situation. I think that's what this is aimed at.
But this says law enforcement. It says it shall be unlawful for law enforcement officers. So you're assuming that law enforcement officers will be there.
There might be 1 or 2 or maybe 10. I don't know how many will be there, but in the situation, the primary responsibility for self-defense is you. Primary responsibility for defending your family is you. Primary responsibility for taking care of your property is you, not law enforcement. Law enforcement comes in when you aren't able to do it, and that's what this bill is aimed at.
Vice Chairman Mumford.
I had a question. I don't want to put the GBI on the spot, but you had some concerns about this bill at subcommittee. Do you still have those concerns with the changes?
Yes, I do. John Blanke with the GBI. I don't have a problem with his repealing it, but the civil penalties are still a concern. You got law enforcement out there, like he said, making the split decisions, and then you're going to have them subject to what's the fine?
$1,000.
$1,000. It's and it doesn't make sense to us. To me.
I'm sorry, Chairman Bordeaux.
One quick question, or maybe 2 quick questions if you offer. Why did you single out law Why did you single out law enforcement for this?
I couldn't think of any other group who could lawfully, under color of law, take someone's guns away from them. Certainly a roving band of thugs doesn't have the legal authority to do so. Law enforcement might have the color of authority to because they've got a badge, a nightstick, a gun, and a flashlight, and they might be able to convince me to turn my gun over to them, even though the law doesn't allow them to.
This doesn't say anything about acting under color of authority. This means somebody who's employed as a law enforcement officer, whether they're on duty or not.
Well, your average citizen wouldn't know.
Why would it be any less onerous for me to confiscate your weapon?
I wouldn't imagine that if you tried to confiscate someone's weapon that they would think that since you're not wearing a badge or anything that you would be having any authority to do so. Someone wearing a badge, I would think, would have authority.
This doesn't say they're wearing a badge. It doesn't say they're acting under color of authority. It says their status as a person acting as a law enforcement officer. Like a law enforcement officer. You're penalizing them, but not me if I try to confiscate the weapon for crazy person.
Now, I would imagine if you tried to take someone's gun away from them unlawfully, that it might not be a pretty outcome.
I suspect for some of these people, I would hope the law officers to be trying to take guns away from. We're talking about a state of emergency here. Why are you singling out?
I tried answering it. I'm sorry it wasn't satisfactory.
Thank you.
Further questions? Any further questions, members of the committee? Representative Bearden?
I'd like to make a motion with record.
Make your motion.
I'd like to make a motion that we substitute the House Bill for
We have a motion by Representative Bearden that we give House Bill 1439 a due pass recommendation. We have a second. We have now moving a second. Is there discussion on the motion? Further discussion on the motion? Hearing none, the chair calls the question. All in favor of giving House Bill 1439 a due pass recommendation, please indicate by raising your right hand. All opposed? That will be sent to the Rules Committee by a vote of 6-4 with a favorable recommendation. Representative Lindsay, you'll come around, please, on 1501. The bill, which, by the way, gives this committee a chance to redeem its good name.
Well,
maybe also the author. Maybe not.
Maybe also. Well, that's not a good way to start. In all seriousness, 1501 is a narrow version of House Bill 720 that raised certain concerns on the House floor. I have proposed a committee substitute, LC 1494-55S, just to make sure I believe it's in everyone's packet. Basically, what the bill will do is simply raise the maximum fine that for an ordinance, for a liquor license ordinance, to up to $2,500. It is a specific concern in my area, but I believe it's an area in other parts of the state as well, in regards to trying to make sure that, for instance, in my area, that the bars in Buckhead follow the law. The liquor license laws right now, the maximum fine is only $1,000. That's been a maximum fine for over 30 years. A lot of these bars go through that kind of revenue in a few minutes. We're trying to raise it up to the maximum we felt could be constitutionally permitted, up to $2,500. It allows the local government a little bit more flexibility. Right now, either they can impose a $1,000 fine if, for instance, a bar is serving someone underage alcohol, or revoke their license. We're trying to provide a little bit more flexibility. I do have, at the request of Georgia Municipal Association a requested additional sentence beginning at line 14. This is coming to the heading of belt and suspenders, just to make sure that we're not taking away any current flexibility of the local governments, and add the following sentence. Nothing in this section shall prohibit the governing authority from imposing a penalty other than a fine. And what that's specifically alluding to is the power of the local governments to, of course, either suspend or revoke a liquor license. That's essentially the bill.
Questions from the committee of the author? Vice Chairman Mumford.
Are you making that as an amendment to your bill? Or
Yeah, that's a proposed additional sentence amendment
and
to.
where is it going? The Legislative Council didn't get it.
I'm sorry, line 14,
Page 2?
page 1, section 1. Oh, I'm sorry. Nothing in this section shall prohibit the governing authority from imposing a penalty other than a fine.
You're offering that as an amendment?
Yes, sir.
Okay, first of all, is there objection to this amendment? Is there objection to the amendment? Jill, are you okay on that?
Nothing in the code section shall prohibit a governing authority from imposing
A penalty other than a fine.
Do you have a question on the amendment? Okay. Amendment question? Okay, Chairman Bordeaux.
Yes, sir.
Is there any possibility that that would open it up to jail time? You're saying that
No, because the underlying, I don't.
because you're saying, I know that's certainly not your intent.
I understand where you're coming from.
It seems to me you'd be saying that nothing. By saying that it's limited to $2,500 doesn't stop you from imposing a penalty other than a fine. A penalty other than a fine is a jail term. Just as
well, already underneath the law, they can impose certain ordinances. They can. They're already allowed certain limited prison time. This doesn't. I believe it's 6 months.
Well, does this open it up to 2 years?
No. This because we're not expanding that authority.
Representative Lindsay, does the language in the sub restrict them from doing anything else they can do under present law?
No.
I mean, I take it what you're trying to get at, license suspensions?
Yes, sir. Yeah, that's exactly what it is. I mean, I don't even mind narrowing it down. Shall impose a penalty. I'm sorry, shall.
So I'm just wondering, and I welcome the input of good legal minds here. If you need the additional language.
In all candor, I'm putting this forward about 3 minutes before I sat down here, and I'm not entirely convinced that I needed it, but GMA requested it just to be safe.
Okay.
But I'll be honest with you, I'm not entirely certain that I need it either.
Chairman
I'll be
Knox.
perfectly candid with you.
I'm not sure what that adds to it. Like, they have the authority to impose that sentence, 6 months under for an ordinance violation currently, and if you don't change that, all you're doing here is raising the maximum fine. That doesn't alter the fact that there's still a possibility of incarceration under a criminal offense, and which is what under present code it could be. But they could impose that as an alternate sentence, or they could do both, actually.
Well, I think the concern was by setting forth a maximum fine that some attorney on behalf of the bar would argue, since you impose this as a maximum fine, you can't also go back and either suspend or revoke the license. That was the concern.
Representative Lindsay, let me, if I may, go ahead and let Ted Baggett with GMA jump in here.
Yes, sir. I'd be happy to.
Thank you, Mr. Chairman. There is a case from about 10 years ago, Court of Appeals case on the Georgia Open Container Law. And the way that the court construed the case, it said because the statute specified a maximum fine The other available penalties under general misdemeanors were not available. And this was that last sentence being added. I think you're all correct in that currently ordinance violations of cities and counties can call for jail time, although it would have to be a pretty egregious repeat violator to never consider that. Revocations and suspensions of alcohol licenses and fines. The intent of this was just to expand the available fine to give some of the cities, larger cities dealing with repeat offenders, some additional flexibility before they start closing. Suspending licenses would be very costly. And the City of Atlanta Legal Department and others were concerned that that old case about the open container law would trip if this amendment went through without some sort of reservation that the other available penalties are still an option.
Thank you, Ted. Further discussion or questions from members of the committee for the author or Mr. Baggett? I'm sure we can get him back up here. Vice Chairman, I'm sorry, Representative Bearden.
Yep.
Once again, Representative Lindsay, can this not be done under a local ordinance by any chance?
No, you can't raise it up. That's the problem. We're already capped at 1,000 under Georgia law.
This moves the cap up.
This moves the cap up for this narrow ordinance.
Just have a problem with it being higher than a misdemeanor, but fine. For a local ordinance violation. That wasn't really a question. I guess it was a statement if you want.
I happen to concur with Representative Lindsay if he's trying to get at the problem of the abuse in some of the establishments in Buckhead.
Yeah.
Particularly with young people. Further questions or discussion? Further questions or discussion? We never adopted the amendment.
Yeah, I'm sitting here working with the language. Would it, if I may, in the way of a question, back to some of the members who had some concern, is this taking care of your concerns? Nothing in this section shall prohibit the governing authority from imposing any other penalty already allowed for under general law or local ordinance. Or is that simply continuing the same?
I wouldn't have a problem with that, I guess.
Okay.
I mean, what are you saying?
Well, like I said, what we're trying to do is make sure that no one tries to come back in and say, well, because you impose a maximum penalty of $2,500, you can't also revoke the license or suspend the license.
Chairman Knox.
We aren't calling it a maximum penalty, we're calling it a maximum fine, aren't we?
Yes,
Penalty
I'm
and
sorry.
fine are not synonymous.
You're correct.
A fine is a monetary punishment that's imposed by the governing authority, and that's not an exclusive penalty. You can have a penalty that also includes, and most statutes do include provisions for both fines and for incarceration, and that's the penalty or the sentence. It's not a, when you impose a fine, you're not excluding the possibility of doing a penalty and as part of the sentence, and that is a penalty, but it's not just a fine.
Chairman Knox, I think your point's well taken. I'm going to withdraw the amendment. I think your point is well taken, because all we're talking about here is a fine. And I'm going to withdraw it.
Okay, there is no amendment. Further discussion or questions from members of the committee? Representative Mangum.
Just for clarity,
Absolutely.
GMA representative was not trying to say that there was a case that held that you could not impose, in addition to a fine, some other penalty or other provision for a sentence similar to what my distinguished colleague, Mr.
Yeah, I think the concern was where this was a maximum penalty, but I think Chairman Knox is correct. The more I think about it, well, all we're talking about is increasing the fine. We're not speaking of about imposing a maximum penalty. We're not necessarily precluding other possible ramifications for violation of the ordinance.
Because it appears that the plain language of the statute says, or any other provisions of general law, the maximum fine.
Mm-hmm.
I'm just trying to make sure I'm clear on where we are, even at my late arrival, Mr. Chairman. Thank you.
I think, given the fact that we simply speak of a fine, and I apologize to the chairman, like I was handing this possible amendment a few minutes ago. But I think given the fact that we are simply talking about increasing the maximum fine as opposed to speaking of the other possible penalties, that we should be okay underneath this particular committee substitute.
Chairman Franklin.
If what we're trying to get at are the people, these clubs, particularly in Buckhead, that are violating the alcohol ordinance, wouldn't a more certain penalty for their violation of the alcohol ordinance be just to revoke their license? Then
that is still an avenue available to them.
What they're trying, something they can do now.
There's something they can do now, but the problem is right now with only a maximum of $1,000. You know, in terms of trying to obtain adherence to the law, we're trying to create a little bit more flexibility with the local government in terms of by giving them authority to impose a higher fine before they go to that penalty, for want of a better term, the death penalty, in terms of their ability to operate a business.
I would imagine, if I could follow up, that it was that an additional $1,500 could be pocket change for some of these establishments based on the revenue that they're getting by operating illegally.
But allowing for a $2,500 fine to be hit on a regular basis, you run up to their ouch factor a lot quicker than you do at $1,000. And I would mind going higher, but in all candor, Representative Franklin, there are certain concerns that we've seen around the country in terms of imposing fines of greater than $2,500 for ordinance violations. If I had my druthers, we'd impose the maximum penalty for this kind of ordinance at much higher, but we did run into certain concerns. And that's why we're trying to take it up to where we were comfortable in terms of being able to sustain it constitutionally.
Recognize Chairman Bordeaux for a motion.
Mr. Chairman, I move that House Bill 1501 do pass by committee substitute.
Second.
We have a motion and a second. Is there discussion now on the motion? Is there discussion? Hearing none, the chair calls the question. All in favor of giving House Bill 1501 by committee sub a do pass recommendation, please indicate by raising your right hand. All opposed?
Representative Beard and I will have a talk.
Y'all are meeting in Buckhead.
That's right. We'll have well, I won't go that far on the record. Thank you very much. I'd be happy to.
All right.
Thank you, Mr. Chairman.
Thank you, Representative Lindsay. Representative Hatfield, House Bill 1222. And while he's coming around, I will report, having chaired a special subcommittee on this bill last week, we had a very extensive hearing on the bill. And I appreciate those of you who served on there. We gave the bill a do pass recommendation out of subcommittee. You have guests with you today.
Yes, sir. Mr. Chairman, I would introduce Mr. Chuck Spahos. He is the Solicitor General from Henry County, Georgia, and Mr. Rob Michael with the Governor's Office of Highway Safety.
Okay, Representative Hatfield.
Thank you, Mr. Chairman. I'm here to present, ladies and gentlemen, House Bill 1222. The Georgia Implied Consent Law basically provides that a person who operates a motor vehicle on the highways of this state has impliedly consented to a test of his or her blood, breath, urine, or other bodily substances for the purpose of determining whether or not they're under the influence of alcohol, drugs, or other intoxicating substances. House Bill 1222 deals specifically with the procedures by which the implied consent law is implemented, and specifically deals with some of the procedures relating to the warning that is given to suspects when they are stopped on suspicion of driving under the influence. Another thing that I would like to point out about this bill, and perhaps first is that this bill will streamline the Georgia DUI code and the code relating to administrative license suspensions that go along with DUI cases. This will have the effect of, whereas right now we have a code that is broken up into chapters where practitioners, judges, and accused persons, when they're looking at the law relating to DUI, they have to go and search around in different areas of the code, different chapters of the code in order to find it. This bill will streamline our code, put it all in one chapter, make it more easily accessible and recognizable for judges, lawyers, law enforcement officers, and persons who are accused of crimes in these cases. So I submit to you this bill is going to do a service for those of us who are in the practice of law and those of us who are charged with enforcing the law. But the meat of the bill goes to, as I said, the implied consent warnings. First and foremost, the bill will authorize the admissibility of a DUI chemical test if the evidence was otherwise obtained by constitutional means. What this means in everyday terms is that if an officer reads an implied consent warning incorrectly or fails to read the warning at all to a suspect, then that will not result in the exclusion of the chemical test from the criminal case, although it will continue to result in the exclusion of the test in a driver's license hearing. The bill also provides that the implied consent warnings will be reduced from the currently applicable 3 different warnings based on the classification of a driver to one simple, streamlined warning which will be read to all suspects regardless of their driver's license classification. The bill will also allow law enforcement to obtain blood, breath, or urine tests by use of a search warrant if there is a refusal by the suspect. But in order for a law enforcement officer to obtain a search warrant, the law enforcement officer will have to have probable cause, just as would be required as the standard for asking for an implied consent test or obtaining an implied consent test generally. The search warrant procedure, of course, will require the law enforcement officer to go before a judge, present his or her evidence of probable cause, and have the judge approve in advance any testing that is done on the suspect. Next, the bill will also streamline the implied consent procedure by allowing law enforcement officers to read the implied consent warning at any time prior to the administration of the implied consent test. Current law requires that that the warning be read at the time of arrest. And as you can imagine, most DUI stops are made on a highway, many times on interstate highways, which are very busy, dangerous areas. Law enforcement officers are thereby compelled by the law to read a warning to the suspects there on the scene of that arrest, regardless of the traffic condition or how many cars might be on the roadway. It puts the law officers in danger, it puts the suspects in danger. This bill will allow the law enforcement officers to read these warnings at a time when it makes most sense to read them, and that is immediately prior to the administration of the test on the suspect. And I find that will probably be the most meaningful time for a suspect to hear the warning, is when he or she is sitting in front of a machine knowing exactly what's being asked of him or her. Next, this bill will add to the list of qualified persons who are allowed under the law to draw blood or urine specimens. And finally, the bill will reduce the legal blood alcohol level for operators of commercial vehicles to 0.02. Current law provides that the legal limit for a commercial driver is 0.04. But I submit to you that commercial drivers who are under the influence pose a much greater danger than a driver of an ordinary passenger vehicle to the motoring public. This legislature should adopt a no-tolerance policy on people drinking and driving in commercial motor vehicles, and that is what this bill would also seek to do. The exclusionary rule, which I anticipate we'll probably have some questions about here today, the exclusionary rule was developed as a judge-made rule which was designed to exclude evidence that was obtained in violation of the Fourth Amendment to the United States Constitution. I would submit to you that this bill, House Bill 1222, does not implicate any concerns concerning the exclusionary rule, because the General Assembly could, I believe, simply eliminate implied consent law altogether, and it would not implicate the Fourth Amendment. However, that's not what this bill is seeking to do. This bill is seeking to make the implied consent procedures common sense and something that is workable for law enforcement officers, for the courts, and for the people, and make sure that the people who are charged have their rights preserved. I think that this bill is a good common sense bill. It is supportive of our law enforcement community. It keeps our streets safe, and it's going to, at the same time, protect the rights of defendants who come in contact with law enforcement in this type of a case. So with that, Mr. Chairman, I would yield and ask for the committee's favorable consideration of this bill.
You have your guest here for question assistance only, is that correct?
Yes, sir.
Okay. Questions of the author or those with him from members of the committee? Vice Chairman Mumford.
I'm sorry, I may not have caught it, but I'm concerned about which LC number we're proceeding under.
This will be LC 292308S. This will be the substitute that is that was voted out of the subcommittee, the special subcommittee on House Bill 1222.
And I know,
Excuse me, Mr. Chairman, will you repeat that? What number?
We're on 2308S. You have that one, Representative Mangum?
Oh,
Okay.
thank you.
All right. Continue, Vice Chairman Mumford.
I just wanted to confirm, I'm looking at LC 282827, and I'm looking at lines 12 through 18, 40-5-201.
I'm sorry, where is it?
It's on page 3.
Page 3.
Section 40-5-201, 13 through 18. There was a previous LC number that contained reasonable grounds and some changed to probable cause. Is that correct?
That's correct.
Can somebody expiate the reason for the change?
I think that the reason for the change, Representative Mumford, is that case law has construed reasonable grounds to essentially be probable cause, and this bill is a recognition, the change is a recognition that probable cause is the standard, makes clear that in every case probable cause is the standard to apply. So this is really not a change in the law. It is simply a codification of what the courts are already holding.
Mr. Mumford, if I could help clarify, part of the reason we did that was when you removed the arrest, the cases that have interpreted reasonable grounds to equate to probable cause discussed the fact that the arrest was involved. Because the requirement of physical arrest was being removed, we did not want a chance the Court of Appeals determining that we were setting up a lesser standard, so we made clear that it was probable cause, because that was never the intent to lower the standard.
I have another question if I might
Sure.
follow up. What is the standard to arrest an individual in the state of Georgia?
Probable cause.
Why then are we, when we are stating that the required level of proof must be probable cause, which is the same standard for arrest, why would we not contend that the person should be under arrest at the time? And by the way, I mean, these people are usually taken somewhere else to have an intoximeter test or blood drawn. They're certainly under arrest at that point, aren't they?
Well, I think the answer to that is we're not saying that the persons won't be under arrest. I think that in every case they'll be under arrest at the time that the warning is read. What we're saying is that you don't have to read the warning out there on the scene of the arrest, that you can bring a suspect into the station, sit them down in front of the intoxilizer, and read them the warning there. They are under arrest, but you read them the warning there in front of the machine so they know what they're being asked to do.
May I follow up?
Yes, sir.
Where in LC 292308S, the new version, are we dealing with the issue of the location where the rights are read?
It's right under where he just was. It's at the beginning of 202.
That would be on page 3.
It'd be directly under where you were just reading 2 representative.
Starting, wait a minute.
It starts top page 4, doesn't it?
This is the deal.
40-5, that's 202, the beginning.
Right. Right. That would be page 3, line 20, subsection A. Prior to the administration of chemical tests to a person pursuant to this article, the implied consent notice.
And part of this, the rule was that it was at the time of arrest. Is that correct?
That's correct.
So at the time of arrest has been deleted, and it's prior to the administration of a chemical test.
Yes, sir.
Chairman Knox.
We've had an awful lot of litigation over the years over the issue of implied consent, where the courts have examined the issue of implied consent, even examined the language of implied consent, and the courts have been setting down some pretty strict standards with respect to what the implied consent must say. If I recall I guess it was in the early 90s, we had implied consent cards changed, and we had the court said those aren't any good. You have to get rid of them. Let's try something else. Try it again. And I assume that there was an excellent reason for that. And it seems to me that we're going back on that now in this new iteration here of requiring that the rights that are given to a person who's holding a license in Georgia are specifically and accurately conveyed to them at the time that they're stopped and questioned, let alone at the time that they're arrested. And so aren't we retreating from all that we've just gone through and solved in the last 15 years or however?
Well, Representative Knox, I appreciate the question. I think you raise a good question. I don't think we're retreating at all. I think that this bill will put DUI cases on an equal footing with every other criminal case that's out there today. Right now, as the implied consent law is administered and interpreted by the courts, DUI suspects are put basically on a pedestal, and they are afforded more rights and more protections through these implied consent procedures than defendants in child abuse cases, than defendants in robbery cases, than defendants in drug cases. We are according special rights and special privileges to DUI defendants, I think, without any reasonable grounds for doing so. What the courts have done, they have strictly construed what the legislature has mandated that be read to the suspects over the years, and that's the reason the courts have taken the position they have. What this bill would seek to do, streamline the warning, make one warning for all suspects, and to point out that a technical violation of an implied consent warning, an incorrect reading of that implied consent warning, will not cause an otherwise constitutionally valid test to be thrown out of court.
I don't recall, and correct me if I'm wrong, but I don't recall that since that's all been done, that there have been many cases thrown out because the implied consent was not given to the defendant. I mean, that's why there's a card there. You read it, and then there's no question about whether you gave them the correct information or not. What I'm seeing here is that you're not saying we don't have to give them some kind of a notice of their rights. You're saying that they don't have to be as concise as we currently have them, on a card that's not being challenged anymore. I don't ever see anybody challenging them on that issue anymore.
Well,
and I don't see any cases being lost on that either.
As a matter of fact, I can tell you, give you a little personal experience on that. I do a substantial part of my practice as an attorney is spent on DUI cases, DUI defense. And I can tell you from personal experience that my brother and I practiced together. We had multiple cases at one time that were being heard on motions to suppress where a state patrolman had stopped some individuals, separate stops, read implied consent to them, but the patrolman, for whatever reason, when he read the implied consent warning, instead of saying .08, he said 8. And courts have interpreted that sort of a mistake as a substantial variance from what the warning requires. And as a result of that, we had motions to suppress granted in those cases, and those defendants walked. That, and I'm not criticizing attorneys for standing up for the legal rights of their clients, but what I am saying is that really should not be the policy in this state. I think the vast majority of persons that I've talked to, and probably most DUI defense lawyers talk to, when you ask them about what the warning said, you ask them, were you read a warning? They may or may not remember even being read a warning, but if they do, they couldn't tell you one iota about what they were advised of. So I submit to you, I think that all the hullabaloo over the implied consent warnings is really overblown. I think that the implied consent warnings are not as valuable to a defendant as many people would like to make them out to be.
But weren't those laws passed in response to the difficulty of conducting a trial, or the state bringing charges and proving a case when we're challenged constantly on whether or not the person's been advised of their rights properly? Because you don't have to give a Miranda in this case. So the legislature, in response to the problems that they were having with convictions in DUI cases, said, okay, you know what? We're going to say, here's what you tell them. You tell them this, you're good. Okay? And so it looks to me like we're going to have to relitigate all that by now taking away what's already been passed in the legislation, been taken through the courts, been taken up, down. And it's been proven over and over again. And I guess you can still get the occasional challenge, but it doesn't happen very often anymore. And that's because they've got the card to read, and they can tell them exactly what it is, and then you don't even have to get into that question. All you have to do is say, "Did you read the card?" Yep. End the story, right?
Well, I don't agree with that. I think that first of all that you miss the fact that that more and more suspects are being advised to refuse taking a test to begin with. And Mr. Spejas may have a little bit he may want to say to amplify on that. But I think that the general message that the general public is getting is don't concede to the test, don't agree to the test, and therefore keep the law enforcement officers from being able to get any usable evidence against this person.
They're not telling them that on the first DUI, are they?
I think that you see that even in the media these days.
You're going to lose your license for a year if you refuse the test, so that wouldn't be very good advice.
But no, I disagree with that, because from a defense attorney's perspective, if I were arguing that, I'd say, if you refuse the test, yes, you have a license suspension, but the law also provides that if you're acquitted of the DUI, that license suspension is lifted. So the odds are you're better off playing the odds and hoping they don't get the breath test to convict you with.
Well, is your experience like mine? Every once in a while I try a DUI case, and you ask the people on the jury, how many people in here think it's unlawful to drink and drive? Almost everybody raises their hand because that's what they think. They don't think it's unlawful to drink a certain amount of alcohol. They think it's unlawful to drink and drive. So there's a bias on the jury. Well, I guess my question is, do you think we're really having a problem getting DUI convictions now?
I think, as I said before, it's the public is becoming more aware of the fact that the way to beat a DUI is not to take the test. This bill seeks to solve that problem by giving law enforcement the tools in those cases where it's warranted, that they can go and ask for a warrant based on probable cause. And that's really, we're going back to that in response to everything that you've raised, is these people that are charged with DUI are going to always have the protection of a probable cause standard. Whether they're being asked to submit to a test, it must be based on probable cause, or whether or not that a court order is being sought, a warrant's being sought for their blood, breath, or urine, probable cause is required. I think that the people who are charged with DUI can feel assured that their rights are going to be accorded to them because probable cause is the standard.
Yes.
Why is it that currently the requirement is that the implied consent be read at the time of arrest?
Because it's in our statute. I mean, simply because that's the way it's written in our statute.
But why do you think it's in the statute? You have an opinion as to why it's in the statute that way?
I don't know that I have an opinion of how it got there. I know how it gets used, and it gets used as a technical means by which to prevent otherwise constitutionally gained evidence from coming in. I mean, evidence is suppressed that was taken without any coercion, without any threat, without any other violation of the Constitution, and it's not coming in because of that provision.
I would submit, Representative Knox, that perhaps when that was originally put into the statute, there probably wasn't a whole lot of thought that went into that specific provision. I mean, I haven't looked at the record, the legislative record on it, but I believe that there probably was not a lot of thought put into that provision. But it's something, as you know, from a defense lawyer's perspective, you look for the details. And if you've got a statute that says you read it at the time of arrest, then you argue that to a judge and say, Judge, this has to be strictly construed, and the time of arrest means when you're there on the roadside. But as a practical matter, that doesn't prove to be workable, safe, or in any way recommended for the safety of law enforcement or the people who are charged.
If you're not under
Got another one? Okay. All right. One more.
Actually, two more. I'll try one and see.
Okay.
Isn't it the case that if you're stopped on the roadside, you're not under arrest simply because you're stopped?
That's true.
You can leave the scene if you want to.
Well, you know as well as I do that the courts, I think that the courts have been reluctant to find a person under arrest simply because they've been stopped and are being questioned, and I think that probably decisions would recognize the fact that even though a person may feel that they're not free to leave, that they're not necessarily under arrest at that point.
The current practice of law enforcement to read the implied consent both at the time of arrest and before they take the test.
I'm not saying that it's not done that way. The statute requires it to be done at time of the arrest, so the second reading would be irrelevant so long as the first reading was done prior to arrest. You can't solve it by reading it at the time of the test right now if you did not do it back at the time of arrest.
Well, if I stop you and I take you over and say, come on over to the station, I'm going to give you a test. I'm going to test give you an intox test, and if you pass it, you can go on home. You don't think I can do that?
No, not unless there's some exigent circumstances that would justify not reading it at the time of arrest.
What would keep me from doing it? If I'm a law enforcement officer, what's to keep me from asking somebody if they'd mind coming over to the station and let me have them take the intox?
Because absent probable cause that they're under the influence of alcohol, both under our current statute and under our proposed statute, you can't invoke implied consent. You've got to have probable cause.
Well, but I'm saying I think I have probable cause, but I'm not sure. If I don't have to read you implied consent, I just say, you come on over to the station, I'm going to give you this test, and then you can go home if it's no good. What's to keep? You're not under arrest. You're just going along with me because I asked you to and you agreed to it. You consented to the test.
Well, you can.
There's nothing wrong with that.
Constitutionally, anybody can consent to a search.
But
The
if
difference
I've
is-
read to you, if you're not under arrest, but I read to you, look, I'm gonna give you this test, and you got a right to have the test, another test performed. If you take this one, you can have another one test, you have your blood test, if you can do this, you're entitled to have another test to verify the accuracy of this test. I don't tell you all that, I just have you come over to the plate, and then you blow .08, now you're under arrest. I didn't have any probable cause till after I got the test. I didn't have to show any probable cause. Once I've got the fact that you agreed to go with me, I don't have to have any probable cause.
The distinction is when you refuse, there's no repercussions. You don't lose your driver's license. There's no other aspect of that. The law is anybody can consent to a search of anything. Our current interpretation of the statute has said, because of the statutory scheme the legislature has passed, that's the only thing that can happen in a DUI case. But it's what we said before. All it does is put them back in the same position as any other person in any other search circumstances.
Except that if I stop you on the road in the middle of the night and you're an average law-abiding citizen, that's a whole different story than somebody that's being accused of murder or some other.
Well, actually,
citizen. I mean, and we're in a gray area here where you have sort of a quasi-property issue because of your driver's license. That's why they call it a license.
Well, I disagree. I think that in both cases the persons are presumed innocent, and I believe that again, as we said before, I believe the legislature could choose to completely eliminate the implied consent procedures, and that would be a constitutionally sound decision. I'm not advocating that we do that in this bill, but I'm saying I believe that you could do that, and therefore there should really be no question at all about the constitutionality of what we're seeking to do in this bill.
Chairman Bordeaux.
Thank you, Mr. Chairman. First of all, let me commend you. I mean, this is a very difficult, sticky area of the law. It's confusing. It's always been confusing. Maybe this does make it a little less confusing. I appreciate you taking this on because it's not been easy, I'm sure. Could you speak a little bit about how the substantive DUI law changes under this? What happens to 391 DUI?
if I could, Mr. Chairman, what it does is it breaks.
He's calling me that now.
No. Anyway, it breaks up the current 40-6-391. You know, it has several different theories of law by which you violate it. One being prescribed, being less safe elements. One being what we've always called per se counts. It breaks that up just as that. Puts one theory by which you violate DUI in a particular code section, and then goes to the next one. I mean, we can go through and show you each one of those, but that is a carryover of the current scheme, with the exception of what we have called driving with a prohibited substance, which is our current per se, and we've made clear that that only applies to Schedule I controlled substances. So it doesn't change marijuana, methamphetamines, cocaine. We did, after extensive conversation with the crime lab and what have you, because you can't draw the distinction and the metabolites over a long period of time of how long that still affects somebody on those drugs. We've left a less safe element as a requirement for conviction on that, so that doesn't change.
So, under the current law, the prosecutor might charge you with DUI and say you're less safe and you were over .08.
And you would still do that here. You would just cite two separate code sections in the alternative. And then we've created a provision for merger for a single transaction. So it would merge the same way it does now.
Right. Has there been, just on a technical matter, you know, many of our statutes talk about what happens when one is convicted of driving under the influence. Which of these statutes is now going to be the old 391 for purposes of
There's a penalty statute. I'll give it to you, but it's a penalty statute, and basically what we did was, if you're familiar with the theft statutes, you know how different ones lay it out, but there's a different sentencing provision for the theft cases. We've done the same thing here. Upon conviction of these, we take you over to the new 40-6-414, which is on page 14.
I've got it.
And starts at 27. And that is current law. The only thing that has changed in there is the one provision on the third life where we had been doing number of days of community service. We converted that to the hours that are practically being applied now.
Yes, sir. What I mean, though, is, and I may be mistaken about this, but I think there are other statutes floating around in the code out there that aren't technically DUI statutes, but they make reference to, for example, this is a bill, and it doesn't I guess this actually makes reference to DUI, but it says superior courts have exclusive jurisdiction over children who's charged with any of these offenses. And it doesn't happen to say driving under the influence, but I'm sure some of them out there do. Which one is that? Which of these 3 or 4 statutes is that now going to make reference to?
The substantive DUI, the equivalent of 46-391 now, I believe, is page 13, line 2440-6-410.
But it's also 411 also, isn't it?
Yes, sir.
And see, that's the, I don't want us to find out that
Right.
that someone's been convicted of ultimately 411.
Right.
You're going to convict somebody of 411, for example, of 0.08 or more blood alcohol.
That's correct.
And not of just unsafe driving.
Right.
And these other statutes are going to, the defendant's going to come in and say, oh, I wasn't convicted of DUI. 410 is DUI. I was convicted of 411.
Right. What it does, that's why there's the first 23 pages or so is the substantive change. The other 40 or 50 or whatever it is everywhere the code referenced it. And what we did, because we've created a new part in an article, everywhere it used to say 40-6-391, we now send it to that new part and new article in the code.
Okay. May I suggest, have y'all gone back and looked just for the term driving under the influence?
We've searched it every way we can with both the help of legislative counsel and the prosecuting attorney's counsel.
Thank you. I appreciate that.
Vice Chairman Mumford.
I wanted to ask the author, I've heard the safety argument that somehow or another providing an advice of rights at the scene of the arrest is unsafe. Have you proposed in this bill anywhere that the batteries of field sobriety tests that are routinely being performed at the scene of the arrest not be performed on the side of the road in the future?
This bill would not affect the field sobriety testing. There's nothing that compels an officer to read the implied consent at the station. I mean, the officer, if he deems it appropriate, he can read the implied consent still at the scene of the arrest if he would choose to do so. Just as he could administer field sobriety tests there on site at the scene of the arrest if he chooses to do so.
Did you consider putting any advice of rights? There's a lot of confusion I found among our citizenry about whether or not they're required to take field sobriety tests. Oftentimes they seem to be misled into thinking that they're under some obligation to take a field sobriety test. That is not in fact the law, is it?
Well, no, that's not the law. But
is it the law under this new proposed statute?
This statute does not address field sobriety testing per se.
I'm wondering why in our advice of rights we don't advise our citizenry that they're not under any obligation to take field sobriety tests.
Well, I would say this much, Representative Mumford, and I'm sure that you're familiar with this as well, that when people are stopped and they're asked to consent to a search of their vehicle, the courts have never held, nor is there any law that requires them to be advised of their right to refuse to consent to a search, although you know as an attorney and I know that they have a right to refuse to consent to the search. This is essentially the same situation we're talking about here in the bill.
May I continue to follow up? Looking at your advice of rights on page 4F, page 4, paragraph F, it's lines 24 through 26. Is that new language or is that existing language?
Yeah, that's new language.
That is new language.
That's new language?
That's correct.
And that essentially is part and parcel of the abrogation of the implied consent.
Could you repeat that?
That is part and parcel of the abrogation of the exclusionary rule as it relates to implied consent.
Well, I don't see it as an abrogation of the exclusionary rule.
Well, it's a continuation. In one section, you abrogate the exclusionary rule in criminal cases, and in this section, you've added a new section, which I assume we're not talking about consent or search to the vehicle. We're talking about a consent or search to a person for the for the purpose of seizing a blood or breath sample.
I think the active part of this section, the part that's important for our purposes here today, is that this would authorize a search warrant procedure in the event of a refusal.
And that's for the purpose of physically, violently seizing a blood sample from a citizen of the state of Georgia. Is that correct?
Well, I don't think that you're going to find an example of any person that's been forcibly required to submit where there's been an evidence of any violence occurring between a person and a law enforcement officer. We went through this extensively in the subcommittee, and I don't think that I heard one person who testified or was heard from on that subcommittee that indicated that there had ever been an incident of violence.
May I continue?
Yeah, right.
Yeah.
While we're on this
Keep in mind,
section,
you got others behind you.
while we're on this section, if we could go down to G.
Mr. Chairman, could I just follow up with one short thing before he leaves that topic that I omitted to say? Representative Mumford, I would again remind you and members of the committee that before the case of Collier versus State in 2004, there was nothing to prohibit law enforcement from getting a warrant. In that case, the court said you can't use a search warrant procedure if there's a refusal. You have to go through this implied consent procedure. A refusal is the end of the line. So prior to that case, there was nothing to stop law enforcement officers from getting a warrant. Now, I think that the evidence would show that was a procedure that was employed in the past, and I'm not aware of any significant incidents of violence that went with those.
Since you went back to F, let me ask you about F. Does F require hospitals and other medical providers to furnish testing that was not done at the request of law enforcement based upon a search warrant?
I don't follow your question.
Where a hospital for its own purposes has taken some sort of a blood test and may have it for their medical purposes, wouldn't this give authority to reach that sample at the hospital?
I would think that a search warrant procedure would certainly authorize that.
And is that authorized today?
Search warrant.
I would think it would. Well, it would probably be authorized by subpoena under current law, not subpoena.
Because of the privacy cases that have come out, what has been said, what the courts have said is before we can have access to the stuff that the hospital took, not at the request of law enforcement, there has to be an independent finding. A search warrant is a mechanism because there has been an independent court make that determination, and that overcomes a privacy issue. This would not allow it in any situation shy of what's current law, and that would be a search warrant.
So the search warrant is already available to obtain is that your testimony?
Of evidence that, for instance, there's blood taken at the time of admission to the hospital.
Right,
for
or
purposes.
even later, some other
Right.
time.
That can be gotten upon a finding of probable cause. Now, there's issues.
By an independent magistrate.
Yes, sir.
Search warrant.
There's issues surrounding what value that has, but it can be obtained by search warrant. That will overcome the privacy issue.
Now, going down to G, I was trying to direct you there. That paragraph represents a change also, does it not?
Yes, it does.
And it deleted full information and replaced it with the terms a copy of the results of the tests or tests.
Yes.
Is that correct?
That's correct.
All right, thank you.
Representative Bearden.
Mr. Chairman, I'd like to have done this one at a time. I've been kind of overwhelmed at some of the things that's been said. To go back to Representative Knox's comment about poaching and pulling someone over and taking them to the station, see what they blow, and decide to make an arrest or not. There's going to be certain items there, probably such as, correct me if I'm wrong, and that's true, maybe weaving. Once you get them out of the car for weaving or an accident, maybe do field sobriety tests. These are the type of things that lead up, and you're building your probable cause to finally go into the arrest and implied consent and get them to the station. Is that not correct?
That's correct. And significantly, this bill does not change the right of a defendant to come in and challenge the legality of a stop, the initial stop.
And once again, with Representative Mumford's comments about addressing field sobriety tests, it's not mandatory they take field sobriety tests, so it shouldn't really be addressed in this.
That's correct.
And also on the violently seizing of blood, as if we're going to beat them over the head and put them down and take blood from them. What we're doing on this right here, before 2004 in the Collier case, if they refused, we had the right on a serious injury or fatality accident, go get a search warrant from a judge, giving the judge a probable cause to get that search warrant to make sure if we got a fatality out there, justice could be brought to the victim and that victim's family. Is that not correct?
I believe that's true.
I was trying to write as quickly as I was hearing these things, and as far as I know, that's about as far as I got with writing. But I appreciate you taking the time to answer those questions.
Representative Everson.
Mr. Chairman, thank you. Page 7. Line 8. Down to 14. Could you expound on that for me just a little bit?
Well, basically the administrative license procedure is triggered when a person submits to a test, and if the results of the test show that the person is in violation of the law, in other words, per se under the influence, then that person would be issued a notice of intent by what is now the Department of Driver Services to suspend that person's license, and the officer would sign the form, that notice, authorizing that person to drive for a period of 30 days. The form would also provide notice to the person of their rights to appeal that administrative decision, and they would then have a hearing before the Office of State Administrative Hearings. That procedure is also raised when a person refuses to submit to a breath, blood, urine test, and the law would provide that a 1-year suspension would result from refusal.
Okay, thank you.
Further, Vice Chairman Mumford.
This section that he pointed out, which I think is on page 8B, paragraph B, 8 through 13, is that what we were just talking about?
We were on page 7.
I'm sorry. Let me take you to page 8B, line 8 through 13. Does that represent any change from current law?
I believe it does.
Doesn't currently the officer have to swear some sort of an affidavit in order to initiate this procedure?
I believe that's correct, but this, if you look at lines 11 through 13, says the signature of the officer, whether actual or electronic, shall be considered an attestation of the officer that the facts contained therein are true and accurate, or true and correct, excuse me.
This was the one done at request of driver services so they can electronically file them. Isn't that what that is?
I believe so.
And currently this would require an affidavit that's notarized?
I believe it does, yes.
The form requires that.
The form.
Is this form, the form proposed herein is not notarized?
No, I don't believe it would require a notary seal or a notarization, but you can read it as it says, lines 11 through 13. It is an attestation that that would be given under oath. And Mr. Spayos just pointed out to me that the department would prescribe the form, so I presume that the department will make a determination as to what exactly would be the best means of making sure that the officer's aware that he's under oath there with that.
Further questions from the committee for the author or his guest? If not, thank you, Representative Hatfield. If you want to step back momentarily, sure. Mike Hawkins had. If you'll come forward, please. If you'd identify who you're with, Mr. Hawkins.
Yes, Your Honor. My name is, or excuse me, Mr. Chairman, my name is Mike Hawkins.
I don't mind.
Afraid I'm a little too used to being in court. I am here on behalf of the Georgia Association of Criminal Defense Lawyers, and I consider myself here as best I can to be here on behalf of the driving public. The first thing I want to tell members of this committee is that I'm a criminal defense lawyer. My practice is limited to defending driving under the influence cases. That does not mean that I defend driving under the influence. In fact, I don't advocate for driving under the influence. I view my role in the criminal justice system as I have a unique opportunity to help people who are charged with this very serious crime. What I do is I advocate for the protection of drivers' rights with all of the energy that I can. There's a lot of police officers here in this room that I have tried cases with, a lot of prosecutors that I've tried cases with. I try and be fair in my dealings with everybody, and I was honored to be asked to serve on the Governor's Office of Highway Safety Implied Consent Task Force, and I have tried to, in that role, to advise members of that organization about what the defense's perspective is. There are several things that I want to say, and I had the honor of speaking before the subcommittee. I will try not to repeat everything that I said before the subcommittee, but there are some members here who did not have the benefit of my comments. The first thing I want to say is that nothing in this bill will do anything to reduce highway deaths or to reduce drunk driving. What this bill does, as candidly stated by Representative Hatfield, is it essentially makes it easier for the prosecutors to get evidence in, and it takes away many of the protections that are afforded to the driving public where police don't follow proper procedure. A lot has been said about this being a public safety issue. And I'm not going to spend a lot of time on it because I think it is accurate that it will be a very rare instance where the police will actually get a search warrant and forcibly hold someone down in order to take their blood. I think that will be exceptionally rare. I think it is also exceptionally rare that what is happening now is that where a person is not arrested, that tests are being suppressed. If I understand what Representative Hatfield told us is, based on a personal experience, he had a defendant where a police officer, a state trooper, misread the implied consent warning, and that he said 8 instead of .08, and essentially overstating the legal limit. It is accurate that the law is where a police officer misstates what the legal limit is, that test will be suppressed because the person hasn't been properly advised. This bill, perhaps because of that circumstance, completely eliminates in the implied consent warning. And let's remember that the legislatures before this legislature sought to create a system of DUI law where it is .08 for over 21 adult drivers, .04 for commercial drivers, and .02 for under 21 drivers. We've created separate and different laws for the different legal limits. This bill has a one-size-fits-all answer to that, and it no longer advises a suspect what the legal limit is at the time that they're asked to take a blood, breath, or urine test. It doesn't tell them in the implied consent warning what test is being asked of them, and it essentially eliminates any requirement that the person be arrested. I want to ask you folks to think about that for a minute. A lot has been said up here by proponents of this bill that what this bill does is it puts DUI on an equal footing with other law, that we can get a search warrant in a child molestation case or an armed robbery case and things like that. And that what this bill does is we've put DUI defendants on a pedestal, and that this bill seeks to take them off of that. Consider, this is just 6 things I've listed just sitting here today where DUI defendants are not on a pedestal, but rather DUI defendants are treated more harshly under our law. For instance, when you are arrested for DUI, and remember this bill takes away the arrest requirement, you are under arrest, taken to the police station, almost invariably handcuffed, put in the back of the patrol car, you're in custody. You are asked to provide evidence against yourself. Evidence that likely is going to determine whether you be convicted or not, whether you blow above a .08. Under those circumstances, When a person's under arrest and being asked to provide evidence against himself in a child molestation case, an armed robbery case, a murder case, that suspect has the right to consult with an attorney before deciding whether to provide evidence. In a DUI case in Georgia, there is no right to counsel. Those of you who heard me argue this before, a lot of folks don't know that. There is no right to talk with a lawyer before deciding whether to take a blood, breath, or urine test. There are police officers here from DeKalb County and from Cobb County, from Forsyth County, officers I've tried cases against and have had conversations out in the hall. It is not unique to the State Patrol that the vast majority of officers, if a person asks for the right to an attorney and says to the officer, I don't know what to do, I want to talk to a lawyer first before I decide whether to take your breath test, that person's going to be recorded as a refusal. That person's going to have their license taken away for a minimum period of 1 year, and that person is going to have an inference against them. Again, there's another place where we've identified where a DUI defendant is not on a pedestal, but rather is treated more harshly under our law. Where a person refuses to give a statement to the police, where he's been under arrest, charged with child molestation, murder, armed robbery, and that person declines to answer a police officer's questions, the fact that the person refused to answer the police's questions, that cannot be used constitutionally against that person in court. Where a person refuses to submit to a blood, breath, or urine case, there is an inference in court that the jury will be instructed that they can infer that the person would have had the prohibited substance that was asked for, whether it be alcohol or drugs. There is mandatory jail time for a first offense DUI. Again, we are not putting our DUI defendants on pedestals. We're treating them more harshly. You can sell cocaine in this state, and you can get a probation sentence with no mandatory jail. In a DUI case, there's mandatory jail. Let's talk about that for a minute. Under DUI law, a nolo contendere, in this statute and in this bill that's before you, it says a nolo contendere plea shall constitute a conviction. That's not true in child molestation, in murder, in armed robbery, and any of the other things that have been said. We have legislated away the meaning in it, unique to a DUI case, that nolo contendere means a conviction. And finally, just the sixth thing just sitting here, did you know that this bill, and under current law, you are not entitled to be treated as a first offender under Title 42, where you have no previous record, and these are misdemeanors. You cannot get first offender treatment. So the notion that the proponents of this bill come before the committee and say, we are seeking to put DUI defendants on equal footing and to take them off a pedestal, have not told you the rest of the story. Significantly, I was interested in Representative Knox mentioning that this is a retreat. I want to remind those who either were part of the legislature or followed the legislature in the law in this area that in 1992, the last major overhaul of implied consent, there was an 18-month period where I was a prosecutor in Rockdale County and Representative Mumford was a defense lawyer. And we lost as a prosecutor 18 months worth of blood, breath, and urine cases because the legislature changed the law on implied consent. Similarly, about 5 years ago, when the legislature changed implied consent and required there to be an exact reading, we lost about a year's worth of blood, breath, and urine cases. And the prosecutors and police officers that are here, probably nodding, will tell you, yes, I remember that. Frankly, from a DUI practitioner's standpoint, I probably should not be here. I should probably be out in the hall and not speaking here because this is going to create a flurry of litigation and it's not all going to be good. There are so many constitutional problems with this that it almost is against my business interest on some level to be here advocating against it. I think that if you all are interested, I have some suggestions about how this bill can come close to being more constitutional. I don't understand why, at a time where we have, over the past several years, made the penalties more harsh and the enforcement more severe, why we now want to retreat and take back some of the protections that are afforded to the driving public. This bill will create less certainty for police officers, and the DUI task force officers who care enough about DUI enforcement that are here today will also tell you that a lot of DUIs are made out there not by the DUI enforcement guys, but mostly by other officers working traffic, stopping a speeder on a Thursday night, smelling some alcohol, and then undertaking to do field sobriety tests. And the last thing that I want to address is the notion of changing the implied consent rules in the manner that's been offered. The reasons for them I really don't think are going to hold up. It doesn't make sense, for instance, to say part of the reason why we want to take away reading implied consent at the time of the arrest is for officer safety and for a suspect's safety. When you consider that you can sit in the back of a patrol car after you've been arrested and be read those rights through the window in the patrol car. You can't walk a straight line like a tightrope in the backseat of a patrol car, yet that's what the police do in order to determine if a person's going to be arrested. You can't stand on one leg for 30 seconds with cars driving by, standing there with your arms at your side, and expect there to be the same amount of safety applied under those circumstances as to why we want to take implied consent away from at the time of arrest and put it down to prior to administration of the test. So, in short, a lot of the attempts here and the reasons for changing the law really are not sound. They haven't been well thought through. And frankly, I'll tell you what my conclusion is on a great deal of this. This is what happens sometimes when there are a couple of cases that the Georgia Supreme Court or the Court of Appeals have decided that are against the prosecution, and the prosecutors get together and they say, how can we fix this? And that's what they've done, and they've done an excellent job at organizing and getting together. But I don't think that they've properly thought through that much of this bill is unconstitutional, and perhaps more importantly, I don't want to be that voice in each of your ears as elected officials a year from now and 2 years from now to be the one to say, gosh folks, I told you so. I told you there was going to be litigation because this is such a severe retreat from our existing law that our courts have done a good job of sewing up, that we're going to go through another period, and it's going to benefit my practice, where we're going to lose a year and a half, or 2 years worth of blood, breath, and urine tests. And the last thing I'll say, in the presence of some of the better prosecutors I've dealt with here and some of the excellent law enforcement officers that I've dealt with here, is that remember, we're just talking about chemical testing. A good police officer, a well-trained police officer, will tell you, I don't need that test to prove my case. In the words of Gwinnett County Solicitor General Gerald Blaney, after he argued before the Georgia Supreme Court, the chemical test, the blood, breath, or urine test, is simply the icing on the cake. It's the evidence that's gathered after the arrest has been made, after probable cause has been decided. And in order to determine if there's probable cause, the officer has to do a good job of questioning the suspect, observing the suspect, properly administering field sobriety tests, and determining if the person has the physical appearances and the mental incapacity as a result of a proper investigation. And if we're putting all of our eggs in the chemical test basket, we're essentially going to be detraining police officers that you don't need to do a good investigation. You don't need to follow proper procedures and use your training. And so I appreciate the opportunity to speak here on behalf of the driving public, and I would be glad to answer any questions that anyone has.
Questions of Mr. Hawkins, Chairman Knox.
I'm still bothered about this issue about not having to get implied consent at the time of arrest.
And I'm thinking that when we put that into the law, that there was a good reason for it, and there was and it has something to do with accountability, that sort of thing. Maybe I'm missing it. Am I off track on that?
Well, I began practicing law almost 14 years ago as a prosecutor, and so I have grown up in an environment, whether as a prosecutor or a defense lawyer, where it's always been required. I think the short answer is we have a situation unique to DUI where you're being asked to provide evidence against yourself after you've been arrested, and that in order to protect the defendant's rights, we want to advise them, here are the rules. If you take the test, we can use it against you in court. Here's what the legal limit is. we can suspend your license if you're above it. That's the law now. Look at what the law, and if you refuse the test, you lose your license for a year. We can use that against you. Look what the proponents of this bill are advocating for. Don't tell them what the legal limit is. Don't tell them that if you blow above the legal limit, your license can be suspended. It only tells them if you refuse, your license can be suspended. That sort of coax them, and maybe a due process violation into taking the test. And it also says, well, you know, Mr. Police Officer, if you don't, even though this law says that you have to read implied consent, there's no penalty if you don't. You may not get your license suspension when it goes to the ALS, but it sure isn't going to have any impact in court. And I suggest to you, and I don't mean to sound so cynical with police officers, but it's true of any job that you have. If you know that there's a consequence if you don't do what's required of you, then you're going to do what's required of you. If there's no consequence, you're going to be less inclined to do it. And this simply sets up an environment where, over time, the police are going to realize there's no consequence to this, and they're not going to read implied consent, because realistically, where you take away the exclusionary rule, you're taking away any incentive for the police. And the last thing I'll say is that the proponents of this bill said that it's important to recognize that this bill doesn't affect the ability of a defendant to challenge the stop of his vehicle. Well, of course it doesn't. That would be completely unconstitutional. You have to be able under our Constitution to do that. Under Miranda, where you're not read Miranda, if you make a statement to the police, the prosecution doesn't get to use that. This is attempting to carve out an exception that may or may not be considered lawful by our courts, to say where you don't read implied consent law, there's no consequence. So it's a disincentive for the police.
Chairman Knox.
Is there also a problem with whether or not there's been a refusal? In other words, if we're going to a standard now that says you don't have to be so concerned about what the actual right is that we're telling you about as far as a refusal is concerned,
okay,
aren't we setting ourselves up for some sort of a nebulous kind of statement about what the law is with respect to implied consent? We're not doing away with implied consent in this, are we?
Well, we're not, but what we're doing away with is any meaningful advisement in implied consent. And as regards refusals...
So if I don't explain it to you, then how do I know, how do we decide whether or not you've refused or not? If I haven't explained it to you correctly, aren't we going to be in an argument every time we go to court over this issue about whether or not you explained it correctly, my implied consent right?
What our courts have said on the consent issue in almost every arena, not just implied consent, is any time that consent's given, it must be knowing and voluntary. And the preview to the litigation that I anticipate if this goes through is I'll be one of the first attorneys to come to court and say this implied consent warning is invalid, it violates due process because my client's consent to take this test cannot be said to be knowing and voluntary where he hasn't been advised of what the legal limit is. I still haven't heard any reason why from the proponents of this bill we're not going to tell people what the legal limit is. We have different legal limits in different states. This bill is going to change our commercial drivers from .04 to .02, where virtually everywhere in the United States it's .04. So you're going to have an out-of-state problem. You're going to have a different standard here, and we're simply not advising folks. But the last thing I'll say on the refusal issue is it's been suggested that the public somehow now knows that it's more beneficial to refuse. I'm not sure that that's true. I think there's probably, in my experience with jurors that you mentioned, a lot of people don't trust breath test machines, or at least people trust breath less than blood. And I think it's unfortunate that the GBI now in the arena that I practice in is being sued as a class action lawsuit where some scientists were caught switching samples and not reporting it. And a federal judge has just ruled that that's going to go to a jury. It's not widespread practice, but it apparently happened. And so I think that there are some things that have happened over the past several years that have shaken people's faith, perhaps, in blood and breath testing.
Representative Sutzler.
Thank you, Mr. Chairman. I want to just ask you, could you opine on the possibility of, if there were an arrest, someone were carried in, They didn't consent to having a test taken. The test was taken. Test was positive. But in court, there was a challenge to probable cause actually having been warranted. That perhaps the officer just kind of had a hunch and acted on a hunch that didn't justify that wouldn't have justified probable cause, but he guessed right, and there was a positive finding once they took the drug test. Would the positive finding be admissible in court? Again, I'm a non-attorney. I don't know. I need you to.
The answer is no, but it's no under the current bill before you and right
existing law. Okay.
Any time that there is going to be a request for this, there's going to have to be a finding of probable cause. The one thing that this bill does is going to create more litigation because now in the vast majority, 98% plus, we have a case where the police officer says, "Mr. Jones, you're under arrest. Please turn around. I'm going to read you some rights." The very few cases where the officer doesn't come out and say you're under arrest, we have to litigate before a judge whether that person was under arrest. Okay, and that's what the proponents of this bill have said. And really, I don't have any stats for you, but just in my experience in watching this and practicing in this area as a prosecutor and defense lawyer, I'm talking less than 2% of cases. Consider that what this bill does, it requires me now, as a defense lawyer, in every case, to file a pretrial motion to ask a judge to determine whether there was probable cause to arrest my client. Because we've taken away the requirement of arrest, I would be not doing due diligence if I didn't ask for a judicial determination in court. So this is going to create a significant amount of more time for prosecutors and judges to devote to this in court, and for police officers to come to court to explain whether there was an arrest or not. I hope that answers your question.
Thanks, sir.
Further questions of Mr. Hawkins? No, Vice Chairman Mumford.
Mr. Hawkins, part of the current implied consent, and I think also part of the proposed implied consent, deals with the right to additional tests. Is that correct?
Yes.
It's essentially not a change in that area, in that it's still included in the device.
Right, but also remember, and I hate to sound like a broken record, it's included in the warning, but the warning is no longer, there's no remedy if the warning's not read. So the failure to advise a person that they have the right to independent testing is now a means to say, if the police didn't advise a defendant of that right, the state can't use their test. That's based on constitutional grounds, but it's codified in the current law. What this does is it takes that out of the implied consent warning, as I understand it. Still, and that's part of the reason why it's unconstitutional.
This current bill would basically set up a situation where someone could, in fact, completely comply with the officer's request. We're not dealing with a person who refused.
Right.
He's asked to take a test. He does take the test. And then he asserts his right or her right to an additional test by personnel of her own choosing.
Yes.
And could be flatly refused, could be told by the officer whatever the officer wanted to tell him.
Okay.
And there's no ability to exclude the evidence under this bill. Is that correct?
That's right, and interestingly also, there's nothing that would exclude it under administrative license suspension. And so if I understand your question, persons lawfully stopped, lawfully arrested, properly read their rights, and they take the test, and then they say, well, I'd like a blood test, and the officer, for whatever reason, denies that request. Yeah, there is, under this bill, there is no consequence for that.
And currently, there is a consequence, because that's considered an important right, is it not? To
Yes.
have an independent test done?
Yes, it's founded in the due process right to gather potentially exculpatory evidence, and it's recognized by the United States Supreme Court, and there's a case called Jones versus State in Georgia that recognizes the right. As drafted, this bill, if it passes, in my opinion, and mine is but one opinion, that's one of the main reasons why I think this is going to be declared unconstitutional.
I have another question, if I might, Mr. Chairman.
Sure.
I am baffled at how the proponents of this bill have, apparently they have elevated the rights in the administrative realm to the driver's license. And I'm not sure in my own mind whether a driver's license is supposed to be a privilege in this state or a right. I've heard that argument for years. I think it's a privilege, is it not?
Well, Bell versus Burson, which is a United States Supreme Court case, says that driving is a privilege. However, once you obtain a driver's license, you have substantive and procedural due process rights. In other words, the state can't just take it away. So it is a privilege to obtain a driver's license. It is a right to keep a driver's license, and it can't be taken away without procedural and substantive due process.
All right. And that is, of course, an important right, is it not?
In today's society, I can't imagine folks being able to raise a family, folks being able to perform their careers, just simply get around, go to the hospital, go to doctor's appointments without a driver's license.
Being an important right, is it more important than a liberty interest?
In my opinion, yeah, it is. Once you begin talking about privileges...
Even if you could go for 12 months to jail when your liberty interest is deprived?
Well, I think a purely liberty interest, meaning if you can be taken out of society and incarcerated, there's sort of a continuum of privilege, right, liberty interest. And in some cases, I think it might go privilege, liberty interest, right. But you have a right to be free from the state violating your due process rights.
Do you think that there may be a constitutional challenge to this bill on the basis that the liberty interest is being sublimated to... I mean, if the right is sufficient to... If the privilege and the right to the license is sufficient to invoke a exclusionary rule, why in the world wouldn't the liberty interest do the same thing?
I understand your question, yes. I think there'll be a constitutional challenge to it, yes.
Chairman Bordeaux.
Thank you, Mr. Chairman. Just a couple of questions. Does it make a difference, other than what is being read, does it make a difference where that implied consent right is being read, whether it's on the side of the road or it's back at the police station right before the test is given?
Under current law?
No, under what... I understand it does under current law. My understanding is this bill changes where it's being read. Does that make a difference?
In what manner? The constitutionality of it?
In terms of, okay, let's start with the constitutionality.
Yeah, I don't think that this bill says you can read it at the station. What this bill simply says is prior to administration of the test. So conceivably, anytime, I keep wanting to say anytime between the arrest and when you get to the station, but keep in mind, we no longer require an arrest. So you can have a situation where a person is not advised that they're under arrest, may not be under arrest. The police officer may feel that he or she has probable cause, but may not convey that to the suspect, and may do exactly what Representative Knox said and say, I'd like you to come down to the station and be tested. And so any time between the time that the police officer determines subjectively, without communicating it, that he has probable cause, between that time, according to the bill, and the administration of the test, it's okay to read implied consent.
Let's take the situation where the defendant is under arrest.
Okay, is he advised he's under arrest?
You're under arrest.
Okay.
You're coming with me to the station house.
Okay.
My understanding is under this bill, the officer does not have to read the implied consent to the defendant, certainly at the scene or at any time up until the breath test is given.
Or blood or urine.
Or, yeah.
So I agree with you.
Does it make any difference whether that's done, that reading is done at the scene or at the courthouse?
Not under this bill.
Right. Okay. Second question is this, and I'm very concerned about something you said a few minutes ago, because I want to know that if I were given a breath test, blood test, urine test, whatever type of test, that it's being administered properly.
Yes.
And it's giving valid results. I want to know that if I'm the defendant, certainly. Yes. I want to know that if I'm the guy's lawyer. I want to know that if it's a fellow citizen over here being administered. I want to know that that test is being administered properly and giving valid results.
Yes.
For the defendant who undergoes the breath, blood, or urine test, what option does he have in terms of getting any test? He can request a test, but none has to be given to him under this bill?
Right. Okay. I'm going to answer your questions in two parts, I hope. Under this bill and under current Georgia law, it is not up to the defendant to decide which type of test that the state's going to administer. The police officer gets to decide blood, breath, or urine. So if you have somebody who's afraid of needles and the police say blood and they say, I'll take a breath test, not a blood test, that's a refusal. Flip side's also true. Somebody says, I've heard those breath tests aren't very accurate, but I'll submit to your blood test. Police officer says, no, sir, I'm asking for a breath test. That's considered a refusal. Once you take the state's test, whatever the officer designates, test or test, he can request all three if he wants. Under our law, you have the right to an independent test. Under our current law, you have the right to an independent test. Under this bill, it gives lip service, that's what I'll call it, to your right to an independent test, and here's why. If the officer doesn't give you, according to Representative Mumford's hypothetical, an independent test, the remedy is gone, and that is exclusion of the state's test. And it also, part of what the proponents of this bill say, oh, we're not taking away implied consent advisement remedies, we're just taking it out of court. It's still going to be available as far as license suspensions go. As I read this bill, there is no means to get a person's license back where they've done everything we just went over. Lawful arrest, lawful stop, lawful arrest, proper advisement of rights, took the test, was denied a right to independent testing. Under this bill, they can lose their license, and it's not a defense to a license suspension to say, hey, wait a minute, I didn't get my independent test. And the state still gets to use their blood, breath, or urine test. So essentially, and again, I sound like a broken record, essentially the portion of this bill that takes away the arrest requirement and removes application of the exclusionary rule takes the teeth out of implied consent.
Mr. Chairman, Mr. Hatfield is shaking vigorously that that's not accurate.
Oh yeah, I'd love to hear if I'm inaccurate.
Hey.
Well, no, I'm not going to. Y'all can have that discussion later. Representative Setzler.
Thank you, Mr. Chairman. Again, I'd like to just have you address the question that's been posed to me by the proponents of the bill, that there's a special carve-out for DUI, that in all other cases, or that rather DUI is the only case that you have these special provisions. My first question to you is, do you know how many other states treat things like Georgia does under current law? And secondly, why are we proposing that the carve-out that currently exists for DUI should be maintained, and we shouldn't transition to something that's more consistent with other charges?
I'll just run through those very, very quickly. In DUI, you have no right to counsel. When you're arrested, you're being asked to provide evidence against yourself. In this state, you have no right to counsel. My research indicates 11 states recognize the right to counsel. In DUI law here, they can take away your driver's license for not consenting to it. They can't do that if you refuse to talk to the police in a rape, armed robbery, murder case. There is an inference against you in court in addition to license suspension if you don't provide the evidence that the state wants. That's not true if you refuse to talk to the police or refuse to let them search your house. There's mandatory jail time in a DUI case. I mentioned before that you can deal cocaine in this state and you can get a probation sentence. You can't get that in DUI. There's mandatory 24 hours in jail for a first offender. In DUI, a nolo contendere under this bill and under the current statute is considered a conviction, so there's no nolo contendere. It's a conviction. You plead nolo, it's a conviction. And then finally, there's no first offender treatment for a DUI defendant that you can get in virtually every other, not every other, but virtually every other offense that you're charged with, including dealing drugs, including a whole host of violent crimes. And so the notion that there's a pedestal that DUI defendants are placed up on, they've only told you half the story. They haven't told you all the things that are unique to DUI. And it's what I call the DUI exception to the Constitution. There's a lot of law that's made that's result-oriented in DUI cases. I think that answered the second part of your question. The first part of your question, what did that involve? I apologize.
It was how many states are currently like Georgia? How many states?
To say like Georgia, and I'm not avoiding answering the question, every state has such different laws. I would say that Georgia probably in our license suspension is not as harsh as many states, but in our penalties, certainly our legal limit is the lowest in the country, but a lot of what you see here also, I think, is modeled after this from this state, this from that state, and it all puts it all here. I'm not sure after this bill that there's going to be a state that is going to afford so little protection to the driving public.
On federal installations, do you know how they manage it? Federal property, military bases?
My understanding is it is the state law applies each installation. But
any further questions of Mr. Hawkins? I hope not. Thank you, Mr. Hawkins.
Thank you, Mr. Chairman.
That was all that had signed up to speak on this bill. What's the pleasure of the committee?
I have some amendments.
Okay, let me recognize Representative Bearden, and then we'll get to those. Representative Bearden.
I'd like to make a motion on House Bill 122 be passed by substitute.
Second.
All right, we have a motion on the floor that we give House Bill 1222 a due pass recommendation to the Rules Committee. Is there discussion on the motion?
I have some.
Vice Chairman Mumford wanted to be recognized for discussion or amendments.
I have, I was going to state that I have prepared some amendments that I'm prepared to offer that I think would improve this bill. And I do want to state that I believe that if this bill goes to the floor and is passed and becomes a law in its current state, that it is going to be found unconstitutional and that there are going to be hundreds of DUI cases thrown out as a result of the constitutional failures of this proposed bill.
Okay. Why don't we take up your amendments if you plan to offer them?
I do.
Okay.
The first amendment that I would offer would be on page 3, line 27 through 32, beginning after the words code section and period. I would strike the informing of or failure to inform the accused person concerning the implied consent law shall not affect the admissibility of such results in any case, including a prosecution for a violation of Part 2 of Article 15 of Chapter 6 of this title, period. I would continue to strike the informing of an accused person concerning the implied consent law shall only have application to and be relevant at a hearing concerning suspension of the driver's license of said person for violation of the implied consent law. The intent of this amendment is to put the exclusionary rule back into play in these cases.
You've heard the amendment. Is there objection to the? We have an objection. Do you move the amendment?
I do.
Is there a second to the amendment?
Second.
We now have a motion to amend the committee sub to House Bill 1222. First of all, does anyone need further information or clarification?
Sure.
Representative Setzler.
I'd like the offer of the amendment to kind of elaborate a little bit more on what it accomplishes.
It basically reinstates that the exclusionary rule would continue to exist where there is a violation of the implied consent rules. I'm particularly concerned where you may have someone who completely complies with the state's request and who request, as they have a right currently, to have additional tests, that the refusal or failure of the authorities to allow them to have that test would not be subject to exclusion, and I do not think that is a result that would be fair or just.
Further discussion on the amendment? I'm sorry, Representative Mangum.
Could I ask the author of the actual bill light of that amendment, is it the author's opinion that, similar to the example that Mr. Martin just gave, that if the person was not given an opportunity to get a different, to obtain additional evidence that will be exculpatory, is it the author's opinion that there should not be any consequence to the failure to give that person additional test?
Yeah, please.
I assume you're talking about a request for an independent test.
Exactly.
If you take a look at page 4, line 20, beginning of line 21, the last sentence there, the justifiable failure or inability to obtain an additional test shall not preclude the admission of evidence relating to the test or tests taken at the direction of a law enforcement officer. So if an independent test were denied for any reason, a judge would have to find that there were a, quote, justifiable failure or inability. So I submit to you that unless there was some extreme circumstances that existed where an independent test could not be obtained, then the failure to afford a suspect an independent test would result in the exclusion of the state's test.
Vice Chairman Mumford.
I want to respond to the author's statement. I read E in that particular section he just quoted exactly the opposite. That it again restates that even though it gives them a reason to say the justifiable failure might be that, you know, we'd have to travel to DeKalb County to take a test, and we don't want to go outside of Rockdale County to take the test. That's not a reason to exclude, and I think that it does exactly the opposite of what the opponent is saying.
Mr. Chairman, if I may just very briefly, this is, Mr. Fayos confirmed, this is current language on our independent test statute, and the courts have already construed this language as to what is justifiable and what's not justifiable. And so this is not going to affect a change in the current law at all. I submit to you that a failure to afford that independent test will result in exclusion of the state's test. This will protect the defendant's rights.
Okay.
This is so you're saying where the language you just quoted on line 21, the justifiable failure. So if you say I failed to or I'm unable to do an additional test, it shall not preclude the admission of evidence relating to the test or test taken at the direction of law. So, wait a minute. You're saying that this seems to tell me that the failure to obtain another test shall not preclude the first test. But you're saying that there is some case law that clarifies this?
Yes, the term justifiable, that's what the whole thing hinges on, is that if law enforcement officers are going to deny an independent test, they better have a justifiable reason for doing so, or their own test is going to be kept out.
But this language said that if you don't do it, your test will still come in. The language you just quoted me?
It says it only if there is a justifiable failure to afford that test.
You say that
if if the failure to afford the test is unjustifiable, then the test is not commissioned.
It does. Okay. With all due respect, though, where does that say that? Because the language you just quoted me, if I break it up, and I'm just bear with me, I don't practice criminal law. Okay. Isn't that right, Mr. Fowler? Long time ago, when I first, long time ago. But just break this sentence up that you just pointed out to me. If I left out the word justifiable failure, just leave those two words out. You got an or right there. So just say the inability to obtain, and you're saying there's case law that says what is able and what's not able?
It was justifiable and what is not.
Oh, okay. So that I don't get confused, let's leave justifiable alone just for 1 minute. Just say that the inability to obtain a test shall not exclude the first test. That's basically what this says.
But I see what you're getting at. I think that justifiable modifies both failure and inability. But I would, if it would make you feel more comfortable about it, I think we can add justifiable and fail in front of inability as well to make that more clear.
Because that's how the courts interpret it.
That's the way the courts have interpreted it. So if you say the justifiable failure or the justifiable inability to obtain an additional test, that should resolve the concern that you're raising, as from what I'm hearing.
Further questions on the amendment?
I'll try to ask a quick one, Mr. Chairman, if I could.
Representative Cecil.
Once again, you may have covered this, but I'm not sure you have. The standard for justifiable, if I'm driving in Eccles County, South Georgia, down there, down in the swamp, and it's
not near the swamp.
or
Better go to the other
heading, and it's 11:45 at night. I get picked up, taken in, county not densely populated, and they, is there widely the availability in the most rural parts of Georgia to get a second test or have some other entity do that? I mean, just for my information, I don't know.
Well, one of the things we've done is expanded, of course, who's qualified to take the state test. They certainly would be qualified to take the blood in the additional test. That's practically what we're discussing, is just taking the sample, not testing it at the time, but acquiring the sample. So practically, it can be the same person that took the blood for the state test can take it for you there if it's a blood test.
Just analyzed elsewhere.
That's right. Once it's preserved, then you can deal with the analyzation at a later point. So it's all a matter of preserving the sample at the time, not testing it right then and there.
Further questions?
One further question, Mr. Chairman. I don't want to belabor the amendment. If you don't have Mr. Mumford's amendment and we do not afford the defendant the opportunity to take that test, the remedy then basically is to argue whether or not it was justifiable or whether you were able to. Is that basically we're basically going to argue whether or not you should have been afforded another test rather than whether or not the first test will be knocked out?
Well, Representative Naaman, based on what I heard Representative Mumford say, his amendment has no impact on the independent test aspect of this. His amendment would essentially gut the bill and require that any variation from the language of the implied consent or failure to read implied consent would result in exclusion of a state test. That is, when I introduced the bill, that is part of the and a major part of the purpose of the bill is to allow a otherwise constitutionally obtained chemical test to be used even if there is a technical violation in the reading or failure to read the warning.
Any further discussion on the first Mumford Amendment? Chairman Bordeaux.
I know we all want to go home, but if I may ask the author to follow up on what you just said. I understand about technical and all that, but what's the penalty under your bill if the officer just doesn't read it at all?
If the officer does not read it at all, the chemical test, if it's otherwise valid, can be used in the criminal case, but it cannot be used in the driver's administrative license suspension case.
So
and a refusal would not be admissible.
And a refusal would not be admissible.
But so the officer can simply know the law, refuse to follow the law. Forgive me, guys, but can refuse to read the implied consent notice, and the test. The suspect can still would then take the test, not knowing what the consequences of the test are, and the consequences of the test is going to be admissible and it's going to be used to convict him.
Right. And if you're .20 or .22 and you consent to the test being used, and you're that far over the legal limit, then it's going to be admissible. Yeah.
But you've got a right to refuse the test.
Nobody's taking away your right to refuse in this bill.
Just they're going to tell you.
And it won't be any different from when your car stopped in a roadside stop and you're asked, will you consent to a roadside search of your car? They don't have to tell you got a right to refuse there either.
So this can take place after your arrest.
So can that.
Representative Mangan.
So now, Mr. Hatfield, can you help me out with it? If I refuse the test under your bill, I will lose my license still. Is that correct?
Yes, sir.
You're not going to tell me I'm going to lose my license?
If you refuse the test and the implied consent procedure is followed, then you will lose your license. Yes.
Okay, what is the procedure then? Are you basically saying you don't have to tell them? Are you saying you don't tell them you're gonna, if you refuse? Let me back up. Are you saying that under your bill that you will not tell them that if you refuse to take this test, you're going to lose your license for a year? You're not going to tell them that?
That's not what the bill says. The bill says that the officer will inform the accused of the implied consent warnings. But the consequence of a failure to inform the accused in the correct manner will be that test cannot be used in administrative license suspension against that person. Okay, but if the chemical test is otherwise valid, then the chemical test can still be used in the criminal prosecution.
Further questions? Hearing none, we'll call the question on Mumford Amendment number 1. All in favor of adopting the first Mumford Amendment to House Bill 1222, please indicate by raising your right hand. All opposed? If you're at the table, please vote. We have 4 votes in favor and 7 in opposition. You want to be recognized for your next one?
Yes, please.
Recognize Vice Chairman Mumford.
On page 17, page 3, line 17, I apologize. On line 17, after the word title, would delete the period and add the words, and said driver is under arrest, period.
I'm sorry, I didn't, Mr. Chairman, I didn't do it.
You want to read it again?
Yes. On page 3, line 17, after the word title, we're going to insert some words. We're going to delete that period and insert the words, and said driver is under arrest, period. This is offered to put back in the requirement that an arrest occur before implied consent is invoked.
Is there objection to the second Mumford Amendment? Representative Bearden objects. Is there a second?
Second.
All right, now we have another motion to amend House Bill 1222 with a second Mumford Amendment. Is there discussion? Representative Mangan.
As I understand this amendment, basically, there is now a requirement that the person be under arrest and then designate what test. Is that? Let me just understand what the amendment does.
This is an effort to return to the current law, to depart from the change represented in LC 292308S, to return to the current law, which requires that a person be under arrest before implied consent rights are given.
cop can't take your blood until you're under arrest.
Can't take. Is that okay? So the question is. So if I understand this correctly, I thought you would read the right before you took the test. Oh, you got to be under arrest. Wait a minute.
Changed it to probable cause. It just says that there's a requirement for probable cause, which, if you recall my questioning of the witnesses, they indicated was sufficient to arrest the defendant. If you have probable cause, if you have an ability to arrest the defendant, what is lost by requiring the defendant be under arrest before you read implied consent, as he is today?
Further Representative Setzler?
Mr. Chairman, I'd like to ask the author of the bill, is there a law enforcement reason that someone shouldn't have to be under arrest to use this?
Well, what you would be doing by adopting this amendment is that you will be continuing, as Mr. Hawkins referred to earlier, you're going to be continuing to litigate really what is the meaningless issue of when is a person under arrest, rather than go right to the central issue, which is whether or not the officer has probable cause. In the context of a DUI stop, probable cause really should be the touchstone of whether or not that implied consent should be obtained and a test done. But this will basically, again, this is another amendment which will basically gut the bill by bringing us back into the arrest provisions, and we're going to be, again, chasing our tails on the question of when is there an arrest, when is there not an arrest.
Mr. Chairman, can I ask a follow-up question, please? So if I were driving down the road and came to a traffic stop and the officer smelled alcohol in my breath because I had had a glass of wine with dinner, only one glass of wine, but a glass of wine nonetheless, and he believed there's probable cause based on glassy eyes, smell of alcohol, whatnot. Was taken in, given a test. I was found to not be positive. I had a negligible BAC. Then there's no arrest. There's no record of arrest. And how is that treated with respect to? Would I then just be released without any? Just trying to understand the significance of an arrest, vice no arrest, and if this would actually be potentially better for the accused if there were no arrest, vice an arrest.
I may be standing to be correct, and we got a room full of prosecutors here who probably also speak to it. But I believe under the facts that you stated, you would be under arrest when you've been taken in, something like that. And I think the practical aspect of this is that when someone is taken in, they're taken in the station, the test has been run, they are under arrest. But the issue of debating when an arrest occurs is something that's a needless exercise here. The question is whether or not, if you've got probable cause to believe a person's been operating a vehicle while under the influence, then that is sufficient under the law to make an arrest. So really the issue is probable cause, not when an arrest occurs.
Why then would it be gutting the bill if they have to put the person under arrest to bring them in?
If I could, Representative Simpson,
please, thanks.
A practical example of an absurdity this law has created now. If a person is under the influence, probable cause clearly exists, they're driving down the road and they injure themselves, okay? What is practically having to happen under our current law is we are having to place that injured person under arrest by our current statute. Now, I see Mr. Norris is here from the sheriff's and I'd be glad to speak to it, but what we're trying to do is prevent to have to play this game of putting that person under arrest where we want to leave them at the hospital and let them pay their own medical bills. We don't want to pay their medical bills. That's a practical situation where this issue of arrest creates this unnecessary determination. I have a case pending right now where the debate was whether or not the officer told the person at the hospital, laying there in the hospital bed, whether or not they were under arrest, to whether or not the test is admissible. When probable cause has already been determined, we're still arguing about whether or not they were told they were under arrest. And it's just
So they're laying in a hospital bed from an injury that came from
their own actions.
An accident, and they were driving under the influence?
That's correct.
Further discussion. Hearing none, the chair calls the question on the second Mumford Amendment. All in favor of the second Mumford Amendment to House Bill 1222, please indicate by raising your right hand. All opposed? Five votes in favor and 6 votes opposed. Going to be recognized.
If I may.
Vice Chairman Mumford.
I have another amendment also on page 3 at line 20 after the letter A, but prior to the word prior, I would add at the scene of the arrest, comma. It would then read A, at the scene of the arrest, comma, prior to the administration of chemical tests. This again would return to the law as it currently exists today. Require reading of implied consent at the scene, which is an important right that the defendant needs to be advised of at the commencement of the DUI case.
Is there objection to the third Mumford Amendment? There is objection. Is there a second?
Second.
We have a motion that the third Mumford Amendment, as stated, be adopted to House Bill 1222. Is there discussion on that motion? Hearing none, the chair calls the question. All in favor of Mumford Amendment number 3, please indicate by raising your right hand. All opposed? The amendment fails on a vote of 5 to 6. Vice Chairman Mumford.
On page 4, line 28, after the words by a law enforcement, comma, I would strike a copy of the results of the test or tests, and I would replace that with the previous language, full information. This is designed to allow the defendant to obtain full information regarding the maintenance and operation and testing of the machine, not just, as it says here, a copy of the tests or tests.
Okay, you've heard the fourth Mumford Amendment. Is there objection to it being adopted? There is objection. Is there a second?
Second.
We have a motion that the fourth Mumford Amendment, as stated to House Bill 1222, be adopted. Is there discussion? Chairman Bordeaux.
Could I just understand what the objection is to giving the defendant information about the tests that were run on them and the quality of the machines run on them, the quality of whether the machines were working or not? It is one thing to just say, here's the test, here's what's spit out, but that's meaningless if the machine is not working properly. Now, I presume it is working properly, but why shouldn't the defendant be able to get that? Why shouldn't it be given that?
I recognize the author.
Now, defer to Mr. Spanos. All we're doing, what this has been used as, they're being used as a backdoor tool to gather all kind of irrelevant evidence. What we're trying to say is, you still have subpoena power, you still have discovery. We just want this special rule in this DUI case that is being used in fact in Florida and some other states. They've sought source codes to the Intox machine, which is the software stuff. What this is getting used to do is say we ought not be allowed to admit a test, and otherwise there's no evidence of it not working or anything otherwise without providing that information. I know the crime lab is here and present and will tell you that they will respond to any subpoena, any response to the Open Records Act, any discovery that we provide. It's that we're not hiding anything and we're providing everything. And then I remind the members that as a prosecutor, I have an ethical bound to provide any exculpatory evidence to a defendant. I cannot sit on any evidence that I know that will help a defendant as an ethical violation, and it will prevent the evidence from coming in.
Chairman Knox.
Isn't it the case, though, that isn't the reason for having this protection in the law is that we were told for a long time under the old Intox machine that, oh, it's working fine, don't worry about anything. We even had, some officials, high officials whose names I won't mention, nor their office, that said, no, these machines work just fine. And then we found out they weren't working that way at all, that there was actually a component of the machine that was not in the machines that we were using across the entire state. And the only reason we found that out is because we had to go through a big rigmarole. A lot of people got thrown in the can because of that machine that was not operating the way we were told that it was, and contrary to the law of the state of Georgia. And we found out that machine wasn't operating that way at all, and that was because they didn't have to tell us what it was in it.
And they didn't tell you that based on this provision. That's what I'm getting at. If it's exculpatory, if I'm sitting on it, if I know it, I got to get it.
But you didn't know it. But my point is that they didn't know it. They didn't know the machine was operating because nobody could get a test of that.
Right, and I don't know how this would change that. I mean, I can't fix a problem I don't know about.
Further discussion.
Chairman.
Representative Bingham.
So basically, I don't understand what the big deal is. Why not just give all the information? You're saying they're asking for too much information?
No, they're asking for information that I don't have. What it's creating, what it can potentially create is a requirement that I go fishing at the crime lab for any problem that they think they potentially have, where they can do that now with a subpoena and that kind of thing. Well, and I use these source codes as an example. They want these copyrighted, trademark protected software stuff that, first of all, I don't even have. But it can be argued that because I didn't provide that, I didn't give full information, so the test ought not come in. That's all.
So you're losing cases because they're asking for this information?
No, they just started filing the motions in Georgia on this. I've seen it as recent in the last couple of weeks, asking for everything potentially under this. This was never intended to be a discovery statute. It was designed, I think what we'll find is the evidence was that if you're going to take a test and they're going to sit there, give them a copy of it. And that's all we're doing is returning to that language. The machine prints them a copy of it, and we want to give them.
Recognize the author of the amendment.
This language about the right of discovery, to my knowledge, has been in this law since 1993. It's been dealt with by thousands of judges and courts. And to argue that it's opening up some Pandora's box to some discovery because of some cases in Florida, the courts are fully capable of deciding what's relevant and what is important and allowing that to be sought and given. This just simply says you just can't hand somebody the ticket that says what they ran. You have more rights than that.
Representative Bearden.
The present machine used for these DUI tests is the Intox 5000. These machines are tested quarterly by the Georgia State Patrol. It's logged down, all that paperwork is kept with the machine. Every bit of that information is accessible. It can be subpoenaed, and it can be taken to court. They're not hiding anything. Those machines are tested. If something's wrong with them, they take them out of commission, and you go find a machine that does work properly. What he's doing right here opens up to things that really has no reason being opening up. Everything is there already for that test. Make sure those machines are working properly at that time of the test. And it's even built in on certain levels. It's got to read between 0.02 grams or less in that area when them individuals take that test. So it safeguards, and they're open to open records or subpoena, and you can get them in court.
Further discussion.
Mr. Chairman,
Call the question. Hearing no further discussion. Call the question. All in favor of the fourth Mumford Amendment, please indicate by raising your right hand. All opposed. The amendment fails on a vote of 4-7. Do you wish to be recognized again? Okay. Thank you. All right. Any further amendments? Any further discussion? If not,
I have one question for you.
okay. Representative Setzler.
To the author of the bill, could you address the issue very briefly? I know that the hour's late and we'd like to move on. But an individual being picked up, carried in, tested, with no right to counsel, no right to make a phone call to an attorney, or is there in fact does that right exist? And could you describe that more to me?
The right to counsel prior to the administration of the test does not exist in the law now. So this bill will not change one thing about that right. I also would point out that just like my example of a roadside stop where an officer may ask a person whether or not he or she would consent to a search. Prior to making a decision about that person has no right to counsel. So this will treat a suspect the same way they're being treated right now, and it in a comparable fashion to other similarly situated cases.
And again, the right to not have counsel now is in the context of a requirement to read an implied consent notice. So that notice is being read to them. They are being read. Hey, you can opt out of the test. Recognize the implications of that. But in the context of no requirement or no consequences for not reading an implied consent statement and no requirement for counsel. It seems, as I read the bill and as I've listened to the discussion, that in fact someone could be brought in. There's no consequences for them not having an implied consent statement read to them. They could be tested without ever being notified they have access or right to counsel, and no implied consent statement being read to them. Am I right?
Well, Representative Sessler, I respectfully disagree with you that there are consequences for not reading that, and that is the state is not going to take their driver's license.
But with respect to the more substantive charge of DUI and things that flow from that, there is no there's no consequence with respect to the main charge. Am I right in saying that?
As the chemical test is otherwise valid, it can still be used. But I would point out in response to your question that think about the practical implications of what you're suggesting. That you say that a DUI suspect is going to have a right to counsel prior to making a decision whether or not to consent to a breath test, blood test, whatever. You're dealing with alcohol, which is something that is it's the detection.
Fleeting, sure.
It's fleeting, right? It's time crucial. You're going to put officers in a situation where they have to inform a person that they have a right to counsel. That person will have a right to be able to get their counsel there or to speak with counsel to counsel with them on those issues. This would completely make law enforcement procedures ineffective at combating DUI.
Is it not true that's part and parcel to some of the provisions of current law that the implied consent clause is allowed for because the logistics?
I'm not going to concede that. I hear you saying that, but I don't know. I don't have any knowledge that the implied consent was in any way, shape, form, or fashion tied to the right to counsel. I think that the main thing is right now there is no right to counsel before you make a decision on implied consent. It's not practical in the context of a DUI case, and it doesn't lead us, or it does not serve the need for searching for truth, and that's what we're really getting. What is the blood alcohol level? Do we have a reliable test? If we've got a reliable test, then it ought to be able to be used.
Thank you.
Thank you very much. Further discussion. Hearing none, the question before this committee is the motion to give House Bill 1222 a favorable recommendation to the Rules Committee. All in favor of the motion, please indicate by raising your right hand. All opposed? The vote is 6 favorable and 5 opposed. This bill will be sent to the Rules Committee with a favorable recommendation. Thank all of you for being here. Before you leave, we will be meeting again tomorrow at 1:30 here. Don't know.
tonight.
Okay.
And,
It'll either be 1:30 or 2. Place to be determined?
I've got a room number in there.
Okay.
And,
We'll have a notice up tomorrow with all the bills to be taken up. There will be a lot of bills to be taken up tomorrow, including some that will get extensive discussion.
None of them are here for that anyway.
Bring dinner.
They're not here for that.
Representative Mangum.
I want to ask for reconsideration of this bill. And I know that that's
You sure? I don't see a need to reconsider, Representative Mangum, with all due respect.
with all due respect, I probably need to leave this one alone. It's not my dog.
All right. Vice Chairman Mumford's subcommittee will meet tomorrow morning.
10 o'clock.
10 a.m.
The reason I didn't do that is I needed to talk to you about